All right. Well, good afternoon, everyone. We're just about past 4 o'clock, so I'm going to go ahead and get started, and we might bring a few more people in as we go through. But I want to welcome you to today's webinar, which will focus on the impacts of the nationwide mass action lawsuit against JUUL, the e-cigarette company, on charter schools and student health in New York. My name is Michael Good, and I'm the Director of School Support for the New York Charter Schools Association. Today, we are joined by Matthew Delforty and William Shinoff, who are local and national counsel for plaintiff schools in this litigation. They will be discussing ways that schools can get involved in this lawsuit, which has the potential to have far-reaching consequences on student health and provide meaningful benefits for schools in their anti-smoking efforts. Matthew J. Delforty is a partner at Shevitz, Furman, and Delforty PC and leads the firm's education law practice. William Shinoff is a trial lawyer at the France Law Group and specializes in litigating complex catastrophic personal injury, wrongful death, sexual abuse, and sexual assault and export cases. So Matthew and William, we welcome you today. Thank you for joining us, and I'll turn the floor over to you.
Thank you for having us. Hello, everyone. My name is Matthew Delforty. As Michael said, I'm a partner at the law firm Shevitz, Furman, and Delforty. See a lot of familiar and friendly faces out there, people I know. We are an education law firm. For the past 20 years or so, I've spent a good deal of time, probably on a daily basis, representing charter school issues and advocating on behalf of the charter school community, which is my great joy. William reached out to me earlier this year, having heard of our work in the charter school community in New York State, and asked us if we'd like to be a part of this litigation that we're about to tell you about. So we educated ourselves a little bit about the issue, vetted the case, vetted the issue, and the more we learned about vaping and the problem that it is, when we understood it and understood that it's truly an epidemic raging and throughout our schools across the country, the more we wanted to be a part of this. We learned as we were educating ourselves that we started asking our clients, is this a problem for you? And one after the next came back and said, oh yeah, absolutely. It's here, it's everywhere. We asked within our communities, I asked my own children, is this a problem in your schools? And one to the next, anecdotally, we learned that 85% were the numbers coming back of kids in high school. And it's not just high school, it's middle school as well. We're coming back and saying, yeah, this is a problem. And the nature of vaping, as many of you know, is such that kids can hide it. They can conceal it. And so the more we learned about this and understood that one vape pellet is the equivalent of 2 packs of cigarettes, nicotine-wise. The more we learned that children were getting sick in very significant, serious ways, whether it be nicotine poisoning or conditions known as bubble lung, that science and the medical community is still trying to understand. The more we understood that this is a crisis, and the more we wanted to be a part of the solution. So we went back to William and we said, yeah, we'd love to be a part of this. How can we help? And as you'll learn now in more detail, exactly what's we're about to tell you is exactly what's going on throughout the country, and the experience that William has had firsthand in other parts of the country thus far with this lawsuit. So we're here to bring New York along, and specifically the charter school community. So I will turn it over to William. We'll at the end of the presentation, we'll be happy to answer every and any question that you have. William.
Thank you, Matthew. My name is William Shinoff. I'm an attorney with the France Law Group out of California. I want to provide you a little bit of background of this case, how we got to actually filing lawsuits against JUUL Labs and Altria, let you know how the litigation has been going, what the goals of this litigation are, and how you all may get involved if you wish to. So the way this all started was I myself actually am I was an education law attorney for 10 years representing school districts in Southern California in the capacity as general counsel and litigation counsel. And the issue during the end of my tenure was across the board with all of my clients. It was becoming a bigger issue, vaping. It was becoming a disruption to the learning environment, and they were all struggling on how to deal with it. I then moved over to the France Law Group, which specializes in representing public entities on the plaintiff side. And I took the opportunity to represent initially my former clients in bringing these cases against JUUL Labs and Altria. And over the 18 months of this litigation, it's developed into a nationwide lawsuit. I currently represent over 450 school districts in 31 states and nearly 100 charter schools throughout the nation. And so what this case is not a class action. This is what's called a mass action. The reason why we don't in our practice like class actions is because to be very frank, class actions are great for the lawyers financially, but do not help the plaintiff. You'd get that gift card in the mail at the end of the day. What we're looking for in this case is to really be able to provide resources to each school district and charter school that do join on to this case. And so the way that we do that is we file individual lawsuits on behalf of each one of our clients, whether that be a school district or a charter school. And so when that occurs is because we have so many school districts and charter schools involved in this case, what the federal court did is they go and consolidate all the cases into one courtroom. That occurred around 18 months ago, and this case is now taking place in the Northern District of California in San Francisco. During this whole time, we've been litigating the case, conducting discovery against these two main defendants who I'll discuss with you a little bit more about their background. During this discovery, they've turned over 18 million documents, and we've defeated 2 motions to dismiss, and we actually are currently on track for a March 2022 trial. And that was the importance of why we wanted to get this information in front of you now, because we are getting close to a deadline for schools to get involved into this case. And so first let me tell you about who the defendants are. The first main defendant is JUUL Labs. JUUL Labs, they own 80% of the vaping market. They started off as 2 young men's doctoral thesis project out of Stanford, and within 5 years became a $32 billion company. And so during that time, as they were growing, they were approached by Altria. Altria is what many of you may know them as Philip Morris. After the tobacco litigation and everything that occurred, they rebranded themselves, and now they're called Altria. Altria then invested $13 billion into JUUL. And what we've alleged in this case and what we've been learning through the litigation that to be true is that these companies, JUUL and Altria, they intentionally targeted children, because if you look back at what the marketing practices were of tobacco, which was Altria, is the concept was if you go and you addict a young person, you create a customer for life. And so because their product is so highly addictive because of the nicotine content, it's explained why we're seeing such high amount of constant usage by the youth. The big issue, though, was the fact that when they did do their marketing to children, they failed to warn about the harms of it. Not until these lawsuits were filed did they start putting labels on the product, warning that it's harmful. They then go and the other issue was the fact that they went and created these flavored pods, which really attracted the children to it. Creme brulee, fruit punch, things that they knew would grab the attention to kids. As a result of legislation posture. There was discussions in DC that they were going to ban flavored pods. That never occurred because at the end of the day, they have a very strong lobby through the tobacco. But what they did do was they did voluntarily take the flavored pods off the market. And now what's left is tobacco flavor and menthol flavor. But menthol flavor still is a very popular flavor with kids. And so due to the fact that they intentionally marketed to kids and they've addicted kids and they failed to warn, that has brought us to these allegations on representing public entities. And public entities have a right to bring these cases under a legal theory called public nuisance. So when companies create a harm to the community and a public entity has been harmed due to these kind of conduct, we're able to go and bring cases like this. And under a public nuisance theory, we not only have the right to seek whatever financial harm our client has suffered, but we also have a right to seek what they call abatement remedy. So that's financial remedy to fix the problem. And so what I'll break down for you is what are we trying to get for our clients in this case? So let me talk about the financial aspect. So first, what we're looking at is what financial harm has these schools suffered to date? Has the schools put in vape detectors? If they have, we need to go and claim that as a loss that they need to get reimbursed on. Have they spent money on educational programs? One thing that we know across the board that we can show is staff time, administrative time dealing with vaping related issues on campus. We've hired experts who are going to put a dollar figure in place based on some questions we would ask you on how much dollars your schools have spent dealing with this based on the salary of those people. Then we look at the future remedy. What do we need to provide to our clients to be able to truly tackle this issue in the future in the best way? And so what our experts have told us is we need to focus on deterrence, support, and education. One way we know that we can deter vaping on campus is by getting our schools the money to put in vape detectors. Those that have put them in, they've seen the vaping numbers drop. The issue is vape detectors are extremely expensive. They can cost anywhere between $3,000 to $5,000 a bathroom. And they also recommend not only putting them in your bathrooms, but they also recommend putting them in your classrooms because unfortunately they created a product that can be done when a teacher's back is turned because it does not leave a smell and it disappears in a second. So if you think about the amount of money it would take just to put it in your bathrooms, that's a lot of money to try to figure out how to get that out of your general fund. So that's one of the things that we're going to be requesting in this case for each one of our clients. Another thing we're asking for is funding for further staff for supervision purposes. This is because the numbers are so high. And let me tell you, nationally, the national average of kids under the age of 18 that are vaping is around 32%. In the state of New York, it's closer to 40%. So this New York State is above the average. And so because we know we can't solve this issue overnight, we need to be able to provide our clients the funding to be able to fund this over a significant period of time. And what we're looking at is to provide you the funds for 5 to 10 years to be able to hire additional staff for supervision purposes. Another thing that we want to be able to provide you is funding to be able to hire counselors to have a background in addiction. We need to be able to provide that support to children so we can help them get off this product for those who are addicted to it. And then finally, what we're also seeking is funding for education. That is extremely important because the gap between what kids and parents know about the harms of this product and what the truth is, it's huge. You know, if you go and you take a group of kids who are vapors and you ask them, is this product harmful or what's in it? 90% of them are going to tell you it's vapor water. There's nothing harmful about it. It's safe because that's what they were told it was safe. So we need to be able to educate them. And when I first started this project, I thought the focus would be on high schoolers. Unfortunately, what I've learned is that this occurs in middle school. And I've even had clients that have told me they've found kids on their elementary school campus possessing this. Even my clients in the state of New York, they've told me this. And so what I do know is we at least need to be able to provide education to elementary school kids about the harms of this because they will face it when they go to middle school. So they can then make an educated decision to say no. And then those that are using it can then be educated to stop. So that's the financial goal of this case, what we're looking to get for our schools. Then we're also looking to create change in this litigation. And unfortunately, from time to time, one way to stop conduct by companies like this is through litigation. And the way us as lawyers do that is through requesting what's called injunctive relief. So that's requesting the court to place an order in place that stops the conduct of these companies. So specifically, what we're asking for is that they stop marketing their product to children, stop putting young people in your ads, using colorful designs, stop being Joe Camel 2.0 again, because it's been very successful what they've done. And another thing we're asking is to not allow them to bring flavored pods back. Right now, they're doing it on their own, but what we have learned is that they were extremely profitable for them. So we want to make sure that they're not allowed to bring those back. Then finally, we also want to restrict their online sales, because what we've learned is the fact that they did not have in place the appropriate settings and security on their website to go and make sure that age verification was done. Because what we were trying to figure out during the time is, how are these kids getting access to this? Well, what we did learn was they were going to the 7-Elevens and they weren't getting ID'd. But what we also learned is that the way they were selling it online, any kid could put in any age as long as it was above the age of 18, and they could go and purchase it without a second step of verifying their age, such as putting in your driver's license number. So we're asking for them to go and make further restrictions on their online sales. So in the end, this case is about providing our clients the resources to battle this issue in the future and not rely on their own general funds or taxpayer dollars to pay for a problem that these companies created. And also we're looking to protect the kids through this case and create change through this litigation. So I wanted to go over the three main questions I get regarding this case and then open it up for any questions you all may have. The first question I get is, what is the time consumption to be involved in this case? Are we going to be deposed? Are we going to have to turn over a ton of documents? Are we going to have to show up to court in California? The answer is no. All that's required for your charter school to be involved in this case is once you do join, is you complete what's called a court-ordered discovery questionnaire. It's about 30 to 35 questions, and it takes, I would say, 1 to 2 hours to complete. That's the only time commitment that you will have to be involved in this case. The second question is the cost to be involved. So we work not on an hourly basis, but we work on what's called a contingency fee. So that means that if there is no financial recovery for you, then you pay no fees or costs. Our fee comes from a recovery. And normally for plaintiff litigation, that would be 40%. But what we've done is we've cut our fee to 25%. And so that would come from the recovery. And in fact, you'll be getting two firms working on the case. And because there are two firms, it's not costing you any more. And so that's how it comes. So in the end, there's no financial risk to be involved. It can only bring in money to you at the end of the day. Then the final question I get is there a risk to be involved? And there truly isn't. You're not going to be sued for suing them. There's no financial risk. And the only risk that I see is that your staff goes and spends the 1 to 2 hours completing the questionnaire, and then there is no financial recovery. But what I have noticed for the charter schools and the school districts that have gotten involved in this is the value that they've seen of letting the parents know that they've gotten involved in this, that they see that as being invaluable in and of itself, because it shows that you're recognizing how much of an issue it is, that you're doing everything you can to protect the kids. And at the end of the day, this is going to create a conversation with the parents, with their students about this, which is extremely important. So with that being said, I wanted to thank you all very much for your time and take this time to answer any questions you all may have.
Great. We'll go ahead and take any questions from the audience. Given the size of our group, if you have a question, you can simply come off mute and ask that. Also, feel free to use the chat, and I'll read any questions that are submitted in the chat as well. So I'll just open it up to any questions from the group.
Hi. First of all, thank you very much for your work. Really appreciate it. This is a good thing for kids, regardless of the outcome. Not to sound crass, but just in terms of understanding what's involved here, what size damages are you anticipating, especially for a school that wouldn't be able to recover the cost of installing vape detectors?
Yeah, so how I would look at it is, so if you didn't have the detector aspect of it, if you're looking at only, if you're just talking about either staff, so because we're looking at staffing, that's 5 to 10 years worth of funding. So that could be a significant dollar figure. Then the educational component, that in of itself based on, and let me kind of give you reference. So our first trial in this case was supposed to occur a month and a half ago in North Carolina. It was the same public entity trial under the same theories, but it was the North Carolina Attorney General only against JUUL. He didn't sue Altria, which my assumption is probably not the best idea as a politician to sue a tobacco company in North Carolina. But his goal in his case, because it was under the same legal theory as ours, so we were hoping to see what a very conservative jury would do, was all he wanted was funding for education for the communities throughout North Carolina. They went to, on the first day of trial, before they even stepped into the courthouse, they settled for $40 million. The educational component in and of itself is going to be extremely expensive because we want it to be a very thorough educational program. So even if you're just looking at the educational component of this case, we see that as a 6-figure recovery. And then all these other components take it increased up. Hopefully that answers your question.
Sorry, muted. You'd think I'd learn after a year and a half of working at home. To follow up on that, how many plaintiffs do you have right now? Is it likely? It seems likely this will probably just settle after the first verdict, right? And then the other plaintiffs would get their, I don't know, some amount that's settled and split.
Right. So it's different because right now we're headed for this March 2022 trial date. And these are huge corporations represented by the 5 largest law firms in the world. JUUL, they want to continue on with their business. They do want to get this behind them. So what we've seen, our expectation against JUUL at least, is that they're probably most likely going to come to us come December, January to discuss a resolution. But the importance of, as I explained in the beginning, is that there potentially could be a global resolution, but in order for us to determine what that global resolution is for all of our clients, we need to be able to have the data from all of our clients before we can make that informed negotiation. And so if there is this global resolution, at the end of the day, your charter school is going to have the choice. Do I want to join this resolution or do I want to keep litigating? The other alternative is that I'm going to be, and I've done this in other cases where I'm resolving 20, 30 cases a day on an individual basis. But at the end of the day, that's the importance of a mass action lawsuit is you decide your own destiny. You decide whether you want to resolve or you want to litigate. And so our expectation is, at least with JUUL, is that based on the facts that are in this case and the jury we're in front of in San Francisco, it's not a winning proposition for them to go to trial. And so our expectation is, at least with JUUL, is that they will try to resolve this the best they can short of trial. Altria is a different monster. They have different valuations. I've heard 100 billion, I've heard 300 billion they're worth. So for them to litigate and to keep going, it doesn't have much effect to them. Mm-hmm. I expect with Altria, we probably will need to go to a couple trials with them for them to understand, because their whole theory is, number one, we're not at fault. And number two, it's JUUL's fault. And 3, if there's any fault, our fault is very minimal. So what they're going to want to see is what will a jury go and put an apportionment, a percentage on us of fault at the end of the day. And so that's what it might take Altria to come to the table. They're hard to read just because of who they are. Sure. One thing that we do have in this case against Altria is we do have a claim of RICO against them. And so, originally that was a criminal complaint.
Sure, so treble damages.
Correct. And so there is that danger. The other danger they have, and they're very well aware of this because they did tobacco litigation and the plaintiffs were public entities, is public entities are not like individuals when you sue. You can't offer a public entity 10 cents on the dollar because they need the money. Public entities, they're not in any rush to get the money. So you can't just throw money and hope they take it. What they do know though is that, and I've heard this from, I probably 30% of my clients have told me this, is that the minute I see a verdict in this case, that's what I'm gonna want. And if they're not willing to pay me that, you're going to trial for me. And that's, that is the risk they run with going against public entities.
And apologies if I missed this earlier. You said it's in consolidated litigation in San Francisco. Is that in federal court?
Yes.
Okay. And how many plaintiffs do you have right now?
So right now I represent around 463 school districts. And as of next week, I'll be at a little over 90 charter schools. Based on my meeting schedules, I think what we'll probably see by December is somewhere closer to 700 school districts and somewhere between 100 to 300 charter schools in this case before trial.
Okay. And apologies if I'm misunderstanding the procedure of this. So if it's in consolidated litigation though, but so that means like the discovery is all consolidated, but the trials are separate?
Yeah, sorry, I should have explained that. So what occurs is in these types of cases is they have what's called bellwether trials. And so the court selects 6 schools to be a representative of everyone. And so what they ended up doing was they chose a small, and by the time when the selections were done, there was no charter schools.
And that's why we wouldn't be deposed or have to go be witnesses.
Right. So what's going to happen is there's been this initial 6, but when we viewed this, the reality is some charter schools could be the same size of a medium school district. Some could be the same size as a small school district. And so we have small school district, medium size, and we have large. And so the concept is that these cases will give the defendants an idea on liability and then also on damages. And so there are these 6 cases set to go. And then what will happen is if we go to trial on all 6, we'll go another round and we'll go another round, and it will keep happening until this case is done. Normally what we've seen in these types of actions is that if they do go to trial, it will take 3 to 5 cases before they start figuring out a way to try to resolve it globally. But what they will also do at that same time is what they'll also try to ask the court is, we want to focus on resolution. We don't want to be in trial. And so what the court tells them is, well, in order for me to go and not have everyone holding in the background, and it's not fair for plaintiffs just to be sitting to the side because you've settled 3 cases, I need to see numbers. And so what the court's going to require them is to show a mass amount of resolutions. I've been in front of this judge before, and that was we're between 100 to 300 a month, them settling cases. So that's what the future kind of holds for us in this. But we're more than prepared. We're preparing for trial. We're not just expecting it to settle. And that's where we're moving towards.
Got it. Sorry, I have 2 more questions. Apologize for monopolizing all your time. 1, who is the judge? And 2, when would we need to decide at the latest if we wanted to be a part of the litigation?
Yeah, so the judge his name's Judge Orrick in San Francisco. And so based on timing, what we're hoping for is the way it works is your board, whoever's making the decision makers who can approve an agreement, once they approve the agreement, we would want you to complete the questionnaire. Once that questionnaire is completed, we then file the complaint for you. Mm-hmm. And during that time too, we're providing all the information to our experts. We want to make sure our experts have enough time to get all the information they need from you in order to provide us the data we need to make the informed decision on what is your damages, what is your dollar figure. So we are kind of hoping that if you do want to be involved, hopefully somewhere between now and early November. But if we're talking more November, at least tell us that you do have an intention to get involved, or at least put it in front of your board, so we in the background can start doing whatever we need to do to get it at least rolling early on.
Got it. All right. Thank you very much.
Of course.
Great. Open to any other questions for William or Matthew?
This is Stacy. Sorry for not having my camera on, but I have a question since we're all New York City charter schools, and the fact that Joel Klein, our former chancellor, is on JUUL's board, and wonder what you're thinking about that is.
That it was an interesting move because it happened after we started filing all these lawsuits for schools, and not only is he involved with JUUL, but the former Massachusetts Attorney General is also on JUUL, and so to kind of give you a little insight of what we've learned in this case, which is we thought it was only the conduct of these companies was their marketing online, social media, but they actually went as far as stepping foot on school grounds, because what we learned is, and you might have received this offer, was around 2017, 2018, JUUL reached out to, especially in the East Coast, to charter schools and school districts to provide anti-vaping education. So then they offered anywhere between $30,000 to $80,000 to put on this education at the schools. And so those who agreed to it, what ended up happening was they would go bring the kids into a classroom, did not allow any teachers in there, did not allow any administrators in there. And they would have someone come in and talk to them about vaping, talk to them about how to use the product. But at the end of it say, oh, but by the way, we don't mean for you to use this. But so what ended up happening was this all came out in a recent congressional hearing regarding JUUL. These kids came forward to talk about it. And what they ended up saying was, it was very obvious. They were trying to tell us that this was safe, this was not harmful, and that they were trying to get us to use it. So they went as far as stepping foot on campuses. And so we thought it was very interesting to see what they did with New York, with bringing that gentleman in. I have no clue what his insight is on this, but it was clearly very strategic of what they were doing, of why they brought him on board.
And so
Sorry.
I'm looking at an article where he says that his goal is to accomplish the paramount goal. JUUL Labs must first and foremost continue preventing underage use of its products. That's all he said. So I just found it curious being.
Yeah, and so what we also always said is they will try to go and spin, if they do resolve these cases, they will spin it in a way that not admitting that it's their fault, but saying that we think this is a problem, but we didn't create this problem. So when they went and settled with North Carolina for $40 million, which is no small figure, they said again, we do not believe we created this issue. We do agree there is a youth vaping epidemic, and we want to help with it. And that's what we're doing by paying this $40 million. And so I can't tell if bringing that gentleman in from New York is somewhat of an intimidation tactic to say, hey, look, they're trying to change. We're bringing in all these good people that were involved with kids, with schools, a former attorney general. It doesn't look like that.
Thanks.
But we speculate, I think, when we looked at it internally over at Chevitz and Delforty, that, it's sort of for the unassuming public, or people who don't go to the next, go do their own research. I mean, he's going to hopefully, in their mind, add some credibility to what they're spinning, to what they're saying. We didn't, we're not all that bad. This is a problem. We want to try and help solve part of it. We're not intentionally trying to do anything. And when you bring in someone like Joel Klein, who ran the nation's largest school system, I think their hope is that, it'll lend credibility to them and whatever they're spinning in the press.
And one thing it has done is that school system has not got involved in this case. However, that has happened.
So Stacy's very good question. Gave me a couple other thoughts. One, who are the law firms representing the defendants?
So to pull it up, so there's DLA Piper. There is, I'll have to go and look at it. I'll be able to send that over to you. But they're firms that are out in New York, Chicago, pretty much the big five that you can think of that are the international law firms. They are the ones that are either representing JUUL or they're representing Altria.
Okay. And then in terms of damages, obviously, I guess it could be different in a settlement, but assuming that there had to be a verdict, do you anticipate like monitoring or anything like that to ensure that the damages are being spent as they're intended?
So how this is working is potentially there could be a grant put in place, as there was what occurred in the tobacco litigation. Tobacco litigation, they created a fund where you could apply to it, get some money out of it, and you had to use it for specific purposes. But that in the tobacco litigation, for those who were filed lawsuits, that was kind of the controversy with tobacco that occurred, was that all these states sued tobacco companies. They got billions of dollars. And when we look back at it now, some of it went to tobacco prevention. A lot of it went to paving roads and doing infrastructure. But in this case, again, we will be recommending to all of our clients that they use it for vaping related purposes. But at the end of the day, it's going to be up to the client of how to use it. But our hope is that they use it. But there's not going to be someone coming back to you the next year saying, give me an accounting of how you use the money.
Thank you.
Of course.
All right, we'll take any final questions. We head to the final 15. All right, I'm not seeing anything in the chat. I'll do one last call. All right, well, I want to thank Matthew. I want to thank you, William, for joining us today. This was really, really helpful, and we appreciate you speaking to our schools on this topic. For our audience, I just want to make a note, as a short programming note, that we offer these more topic-specific webinars on a regular basis. We also do our statewide monthly webinars. Those occur on the second Tuesday of each month, and we use that as an opportunity to share any major updates and to allow state authorizers as well to share their updates. So please keep a look in your email for communication around both the topic-specific webinars and our monthly statewide webinars as they come through. And to speak specifically, we do have an upcoming topic-specific webinar on Tuesday, August 24th at 4 p.m. The topic for that webinar is going to be vaccine mandates and testing. We'll be having a legal and medical expert talk about issuing a vaccine mandate within your schools and also staff and student testing. So the link for that webinar is being shared with you guys in the chat. We hope to see you there as well. So thank you once again for attending. Have a great rest of your day.
Thank you.
Thank you.